Assalamualaikum warahmatullahi wabarakatuh. We are from a group of three, which consists of me, Alif Izzaturrohmah, Erinda Nur Aysiyah, and also Deska Dwi Seylianki. In this video, we will present an article entitled The Preamble in Constitutional Interpretation. Let's go straight into the discussion. I am Alif Izzaturrohmah. Here I will discuss how to talk about opening. A foreword is a preface to the Constitution and usually contains the formal title. Preamble, or some equivalent alternative title, will in another case it appears without a title. The contents of the opening can be classified into five. The first, the sovereignty. Most of the preambles mention the sort of sovereignty. In some cases, sovereign power is in the hands of the people. We are the people. This is a relatively neutral term that a large portion of the population can usually identify. Second, historical narrative. This opening includes narrative, the stories of a country, nation, or telling specific stories rooted in language, heritage, and tradition. The third, ultimate purpose. Openings often highlight the fundamental aims of society. The fourth, national identification. The preamble usually contains a statement about the national creed, understand constitutional belief about the attitude of the state and its constitutional philosophy. And the last one, namely God or religions. The preamble may include reference to God. Several preambles emphasize the supremacy of God, or other preambles also refers to religion. Next, that is American opening. One of the United States' greatest contribution to the world is the U.S. Constitution, and perhaps the most influential part of the U.S. Constitution is the opening. The current opening differs from the original introduction in 1787 of the Philadelphia Convention. The preamble refers to people as source of authority and outlines 6 lofty goals: to form a more perfect union, build justice, ensure domestic peace, defend each other, promote the common good, and secure the blessing of freedom. The next discussion, namely legal status of opening. The opening has several functions. First, the preamble has educational purpose. It is one of the most important pieces of the Constitution, mentioning the educational and public areas. Second, the preamble has an explanatory purpose. It serves to determine the reasons for the entry into force of the Constitution, the reason for it, and the immutability of ideals. Lastly, the unifying. It is a political surcharge to consolidate national identities and serve as a national calling card. The last one is symbolic opening ceremony. The concept of the ceremonial symbolic opening was first collaborated in Plato's law. Plato's idea of preamble is meant to justify the law. Preamble to the U.S. Constitution is an example of Plato's preamble concept because it is persuasive, symbolic, and in general, universally.
My name is Erinda Nur Aysiyah. Interpretive preambles. This common law rule remains effective on the Constitution level instead in which the Constitution's preambles embodies a guiding framework for constitutional interpretation. When several interpretations exist, courts prefer the option consonant with the preambles. A proposal to amend the preambles by adopting a non-justiciable preambles offered by a Constitution Review Group was rejected. Substantive preambles. While fundamental political decisions may appear in the text of the Constitution, or not be in the text of the Constitution at all, they most often appear in the preambles. An example that governs Constitution interpretation and express Smith's notion of fundamental political decision is to be found in Francis' integrative and disintegrative power of preambles. The preambles strike lies not only in the legal sphere but also in this social function and effect. The United States probably has the best example of an integrative preambles. This occurs when a preamble reflects only the story of a dominant group. Purchases are briefly discussed here: Macedonia, Israel, Australia, and the EU.
The Macedonian experience. The preamble to the 1991 Constitution established Macedonia is the national state of the Macedonian people, and referred at length to their history, culture, and identity. It was a strictly Macedonian preamble in the ethnic sense, noting on the historical, cultural, spiritual, and statehood of the Macedonian people. The preamble stated that Macedonia was founded in order to serve as the national state of the Macedonian people, as well as other nationalities that reside therein. Under pressure from the Albanian minority and the international community, the Macedonian preamble was amended in November 2001 following the Ohrid Agreement in August 2001. The Israel experience. Israel is considered to be among the few democracies not having a formal written constitution. In fact, one of the historical reasons for the failure to establish a constitution stems from the inability to accept consent regarding the preamble content. This amendment included two important sections declaring for the first time that Israel is principle set forth in the Declaration of Independence. The purpose of this basic law is to protect human dignity and liberty. In order to establish in a basic law the values of the state of Israel as a Jewish and democratic state. Legalization of the term Jewish state has granted to court the power to decide the meaning of this character and has triggered social tension between secular and ultra-Orthodox Jews admit with Jewish and Arab citizens by adopting a constitutional division of Israel as a Jewish state. The basic law excludes them from the Israel mainstream and treat them as second-class citizens. The Israel experience demonstrates how the preamble design and rise ideological barriers to social integration as well as product feelings of not belonging. The Australian experience. Australia was established in 1912, the Commonwealth of Australia, on November 6, 1999. A referendum was held on the question of adopting a new preamble. One of the reasons motivating and referendum was the need to reconsider the legal status of Australian Aborigines. In February 1998, Constitutional Convention adopted a new preamble that would enable minority groups to identify with Australia. Prime Minister John Howard announced his intention to abide by decision regarding a spirited referendum on the new preamble. Aborigines not be mentioned as a native minority, but as the custodians of our land. The EU experience. On December 1, 2009, the Treaty of Lisbon entered into force. The things inserted in the Treaty of Lisbon's preamble express the differences in the conceptual framework of the rejected draft treaty establishing a constitution for Europe. At the end of 2004, representatives of the EU signed the draft treaty establishing a constitution for Europe. Another interesting discussion took place regarding the question of whether to refer to God or European Christian heritage. The similar debate arose surrounding European common history, Constitution for Europa was very detailed. The preamble is much shorter. It merely declares a modest goal of enhancing the efficiency and democratic legitimacy of the Union and to improving the coherence of its action. With no united people of Europa, little common history, and fewer shared goals, the question of having a European identity become more significant. Conclusion: the preamble's purpose is not only, perhaps not mainly, to guarantee right or provide legal argument, but to set down the basic structure of the society and its constitutional. In no other pledge than the preamble is the constitutional understanding of the founding fathers and the national creed so clearly reflected. Preambles have an important non-legal purpose as well. That's all we can say, more or less we apologize. Akhirul kalam, wassalamualaikum warahmatullahi wabarakatuh.